My sweater on so I can survive in a barn dwelling. Oh, look, there goes a barn owl. Huh. I wonder why. It's probably because it's cold. Barn owls love the barn.
So we're muted. I believe we're muted. Yeah, we're.
What?
Maybe we're not muted.
Hi, Joe.
Hey, Joe.
How y'all doing?
Good. How are y'all?
Hanging in. It's kind of a dreary day over here.
Yeah, Nashville winters.
Marion, are you back yet? Or are you still?
No, I'm in Nashville. Be
How's
going back
your family?
there.
How's your family up there?
Oh, they're doing fine. It's worrisome because she's, my daughter works in the hospital, although as a surgeon, she's not as much in contact with COVID patients, but she expects, given the surge, that she'll have an easy week or two with not too many surgeries, and then she'll be asked to work the ICU.
Oh, yeah.
So
That's
we're
rough.
just staying on the ready so we can go up and take care of the little guy.
Yeah.
So worrisome.
Yeah.
I guess it's as bad up there as it is here.
Yeah.
I think is it worse, isn't it? It's pretty bad. Their hospital capacities.
Yeah, it might be. Madison is very compliant, but the rest of the state is not. And they're a big feeder hospital because Wisconsin, except for Madison and Milwaukee, is mostly rural.
What's her surgical specialty?
Well, right now she's in her last year of general surgery, and then she's in for 2 years of fellowship in transplant.
Yeah, so
Okay, so,
you can enough to share if you like.
no, it looked like there's just one cup left.
No, there's enough, big heads, civilians,
Oh, okay.
We'll all mute eventually, I'm sure. Yeah. Well, that's hard. It's hard not knowing. Yeah. Having to live on the edge. That's a tough place.
Oh, we're so much more fortunate than so many other people.
I know. That's very true for probably everybody on this call.
Yeah.
We're so much more fortunate, and it's hard.
Good morning, Jim. Good morning, everyone else.
Hi, Carol.
It's Carol, yes.
You hear me?
I hear you just fine.
Okay, good.
Sorry, there was a mix-up about how to make you connected.
No, I got this about 45 minutes ago, so it was fine.
Good. We are so appreciative of having you here to talk about this topic.
And I'm planning to speak for about 25 to 30 minutes. That's my
That
understanding.
is absolutely perfect. Yes.
So, and I'm glad to spend the other half hour responding to questions if people have them, so it would be fine. Many of the issues I'm going to talk about are very current.
That's kind of my thought on this one.
Some,
On a daily current, eventually, it's crazy what we're doing with.
crucial.
Yeah, when you're hearing things 2 nights ago on the news that are directly related to what you're going to talk about, it's kind of like, oh my gosh, are we relevant or what here?
Yeah.
So I bet you've never spoken more relevantly.
Yeah, well, I'm gonna try to put it into a broader broader context, being an academic context is important.
I'm not surprised to hear that. I don't know if anybody has said this to you or not, but I will. Madeline will kind of do a little bit of league business at the very beginning, and then I will introduce you, and then you will be on go.
And how many folks do you expect to be?
Have no idea.
We never know.
Yeah, we never know.
They just show up.
It has varied literally from 20 to 50. So I think dreary weather might help us out a little bit. And I don't know what else might help us out.
I think it's going to help people out. I think.
Yeah. Oh, I think the topic definitely, yes.
We just have to, we give it a little bit after 12 before we start because there are always people still trying to get on.
Sure, some people haven't seen Judy Sachs, haven't seen you in eon. So nice to see you. And Karen Weeks, I see, is on the call. It'll be nice to see you after it's been a long time.
I have a feeling there are lots of people that you're going to recognize.
And Maureen Ott, so it'll be nice to see you too. When you're like, the group is like my students. Some have the video and some, I can never quite figure out why people are on the video or not on the video. Is it the bandwidth? Some of my students, the bandwidth problem that they and their spouse or partner or roommate can't be on a Zoom call at the same time. They don't have enough capacity, which I don't know. Quickly running out of his expertise or understanding about how this all works.
Yeah, just so you know, 61 people had registered as of this morning. So that's a good number. We'll see if all 61 get on, but half is good.
Yeah, my little count says 27 right here, and I think that includes me.
Yeah, I got you.
I just put my 2 dogs in the basement with a couple of bones, so I wouldn't have that as an issue.
I'm going to give it one more minute. Right now we're at 35 and we'll see if anyone comes on again. because we don't want to miss the important things in the beginning, as well as Professor Blumstein. Okay, so I want to welcome everyone to our monthly Hot Topic session. As you know, it happens the first Friday of every month. And it is open to the public, not just to league members. So if you have friends and would like to know the information that we share, you can send them to the league website, lwvnashville.org. And there will be a recording of this topic and it will be posted in the next few days, as well as you can tell them to come to our January Hot Topic, which will be Stuart Clifton talking about the upcoming General Assembly and the sessions that will affect all of Tennessee, as well as the bills that will be presented and dealt with. Other than that, the important thing is to continue to keep yourself safe so that you can be around in January, and to remember that the league is an ongoing, hopefully upward moving organization, and our membership is key to us affecting the goals that we have set in place. Be sure to read the newsletter this coming month, which will be out on the 17th virtually and within a few days if you get it in mail, because there's going to be information about an exciting program we're rolling out in January. And with that, I'm going to turn it over to Carol. Carol?
Thank you so much, Madeline. I am really excited, particularly at this point in the history of our country, to have Jim Blumstein as our speaker. Is there a problem? No?
No, I can hear you.
Okay. I was getting signs from Madeline that something was maybe wrong. Okay. We're delighted to have you, Jim. Jim is a constitutional scholar of long standing. He's argued cases in front of the Supreme Court, but he also is an outstanding academic scholar and has been awarded numerous awards, both at the university and by outside groups, for his excellence in law and medicine. And also he has been designated as, I'm trying to think what it's called, one of the 8 university professors at Vanderbilt, which is an extraordinarily coveted award that he was given. And so without further ado, I'm going to let him talk about all the things that he knows a whole lot about and enlighten us in the area of constitutional law and presidential responsibilities. So it's all yours, Jim. One second. Afterwards, we're going to have questions. So hold off until the end, and we'd be delighted for him to answer any questions you might have. Thank you, Jim. Go on.
Thank you, Carol. It's really a pleasure to be with the league. This is not my first rodeo with the league. I've been involved in league activities really since I arrived in Nashville. It's hard to believe 50 years ago, but Sally Levine was an important liaison. We worked together on some election law issues, and I've spoken to the league before, and actually the league has been one of my clients. Some years ago, I took on a case on behalf of the league, and Barbara Chazen's daughter was also a plaintiff in the case, and it involved absentee ballots, which is very much a current issue before us. I'm going to cluster my comments around 2 or 3, depending on how one wants to organize it, topics and themes. First is I want to talk a little bit about the culture of constitutionalism. I don't think one can talk about executive power or about constitutional law without an understanding of how important the culture of constitutionalism is. And I'll be talking about the importance in that regard of self-restraint. And then I'll be talking about the executive powers in the context of the broader theme of separation of powers. Can or should politics be taken out of the political process? And I'll be identifying the concept of the unitary executive as part of checks and balances in our federal system. And then finally, I'm going to talk about constraints on executive power, and specifically about some of the limits on the president's power to issue executive orders, and the constraints imposed and the philosophy underlying the independent agencies, which are now really being called into question again in some academic writing and in political advocacy. The Administrative Procedures Act puts some procedural constraints upon executive branch authority and requires that the government, where the APA is relevant, that the government explain and justify behavior that it takes. And so I'm going to cluster around those 3: culture of constitutionalism, the executive power in the context of separation of powers, and then constraints on executive powers, and especially under the statute, the Administrative Procedures Act. So those are the 3 themes. So let me talk a little bit about the culture of constitutionalism. I'd like to emphasize this because the Constitution is just a pretty sterile written document if there's not a commitment to the concept of constitutionalism. And really, of all the things that are happening now, many of which are pretty unsettling, the importance and the effect of our culture of constitutionalism is really a bedrock of constitutional guarantees. For years before the fall of Saddam Hussein, I used to bring out to my con law students a copy of the Iraq Constitution. And you would think you would be living in nirvana, in heaven, to live in Iraq during the Saddam Hussein era. And you'd realize that there are all these pie-in-the-sky promises in the Iraq Constitution, none of which meant anything because there was not a commitment to abide by the Constitution and no method of enforcing the constitutional guarantees. The current debates and discussions and so forth that we're seeing really pushes the edge. But one of the things, maybe leave it up to me to find a silver lining, but there's a big silver lining in what we're seeing now, is that there's no doubt that a candidate, in this case the president, has the right to seek legal recourse if he thinks that there are violations of his rights. But there is a process that's set out for that. And the process requires evidence, proof, and before typically a court or some other arbiter. And there's a role for politics in this too, but it's a constrained politics. And what we've seen is remarkable devotion. Georgia is the most recent example, but it's true in Arizona, in Michigan, Wisconsin, and Pennsylvania, all states that Republicans control, at least the legislatures of which they control. And the president has made a push to getting a political resolution that will be favorable to his outcome. And he's met with strong resistance. This is part of the culture of constitutionalism, is that there's tremendous pushback. And without that, there would be a very different outcome. And so I think that this is part of our sense as a society that uh, we exercise what's critical is self-restraint. You can't have a culture of constitutionalism without some notion of self-restraint, which is to abide by rules, abide by outcomes, even if those outcomes are not ones that are favorable to you, at least in the short run. And so I think that the restraint that we've seen on the part of, in this case, the legislatures in 4 or 5 of those states that I've mentioned, who are so-called battleground states, is extremely important. And we're going to see a test of this, which I'm going to talk about in a moment, where there are contests. There are 2 races for House of Representatives now that are basically in very close elections. In Iowa, there's a House race where the candidates are separated by 6 votes. 6 votes, 6. Not 16 or 60, but 6 votes. The Iowa process has certified an outcome, and it's given to the Republican. The Democrat is not happy with some of the elements, and she has the opportunity to appeal to the House of Representatives. And the House of Representatives has responsibility for making the final adjudication. I'll come back to that. Same thing's true in New York State. There's a district, I believe it's the 22nd Congressional District, where the parties are separated by the last count of 12 or 13 votes. And it's being adjudicated not through a political process as in Iowa, but through the court. A judge is monitoring this and so forth. And so there's a lot of debate about this, but when these debates have occurred in the past, and the most recent, I think, was in 1984 in Indiana, the parties agreed, they fought it out, they made their best case, why certain votes should be counted or not counted, and ultimately the parties agreed to abide by the outcome. And finally, in this regard, we saw in Bush v. Gore in the election of 2000, Al Gore is a former student of mine, and Al lost Florida by a very small margin. President Clinton was in control of the government. The case went through a process of counting and recounting. Supreme Court weighed in, and neither candidate, Bush or Gore, and certainly not President Clinton, challenged the authority of the adjudicative process to be authoritative. So that is what I call the culture of constitutionalism, an agreement to live by, to fight it out. But at the end of the day, when the process is ended, we don't have a war, we don't have assassinations, we have grumpiness, but we agree to abide by the outcome, and some more happy than others. So self-restraint is the critical element here, and that's an essential element of democracy and constitutionalism. So let me give an example. In the Iranian hostage crisis, when President Carter was in office in the late 1970s, 1979 and 1980, President Carter suspended claims in court by U.S. entities and individuals. So if you had a claim against Iran, you lost that claim, and all the claims were channeled through a special tribunal. And there was no specific statutory authorization for what President Carter did. When President Reagan came into office, he reaffirmed what President Carter had done. And ultimately, in the Iranian assets case, Dames and Moore v. Reagan, the Supreme Court validated what President Carter had done and what President Reagan had reaffirmed, even though there was no specific statute that authorized it. But the reason I'm raising this is that even in the absence of a specific statute, the meaning of presidential power, the meaning of how our entities of government live together is a product of custom and practice. Custom and practice is often strong evidence of how things are designed to work. So you look to the history, the court in that case looked to the history of congressional acquiescence in suspending of claims to settle these international disputes with foreign governments. US presidents had this authority, and that they had enacted the authority, and it had been long agreed to by Congress and by the president through custom and practice. So it's important that there be a sense of agreement. Part of custom and practice is acquiescence, and that there's not a challenge, that there's agreement. And so this explains why sometimes we see lots of vocal opposition, because the courts have said that in the absence of vocal opposition, that suggests that the parties have agreed to a particular process or procedure. And so therefore, we lawyers would argue that if my client was the House or the Senate or the executive branch, and they weren't happy with certain outcomes, they have to make noise about it, to let it be known that they're going along, but they don't agree with this. This should not happen in the future. Custom and practice not only has legal effect, but it also has a political dimension. How something has been done is often evidence of how it was meant to be done. And my example here is if you're in a relationship or a marriage, and and I take this from the husband's point of view, and you for years have taken out the trash. Then all of a sudden you decide, well, maybe it's really not right. I don't want to keep taking out the trash. Sorry, that horse is out of the barn. If you've been taking out of the trash for 30 years, you're going to be expected to continue to take out the trash. That's part of the deal, that you were understood to have that as your responsibility. That doesn't mean that terms of a negotiation can't be renegotiated. They can be, but there has to be a process. There has to be a conversation. There has to be an agreement that says, well, I've taken on a new job. Taking out the trash is awfully difficult at this time. Sometimes I travel. We need to renegotiate our deal. So I'm not saying it's locked in concrete, but in the absence of some renegotiation, in the absence of a conversation, the evidence of how things have worked for 30 years is the evidence of how they will continue to work and how they were designed to work and how they should work. And so this is an example in our political arena and I go back to the confirmation hearings of Professor Bork, Bob Bork, who actually was my constitutional law teacher, one of them in law school. He was a very engaging and very tough and challenging teacher, and he and I used to have arguments in the seminar. I must say that he wound up influencing me more than I think I influenced him. But we did have a discussion in class, and he was very open to that, and he loved an argument. And he was an ex-Marine, a very tough, kind of a tough negotiator. When he was nominated, there had been a long expectation that the standard for appointment to the Supreme Court was qualifications and competence and integrity. And Bork certainly qualified on all those grounds. He was an intellectual leader. He was a man of great integrity. He was very smart. He taught at Yale Law School for many years. And if you disagree with him, he welcomed the disagreement and was willing to kind of duke it out with you on an intellectual basis. So on the traditional criteria, he certainly would have measured up. But he had a judicial philosophy that was very foreign to the prevailing judicial philosophy on the part of many senators. And so they fought him, but they fought him on grounds not relating to competence or not relating to integrity or ability, but on grounds of ideology. This was a new frontier. And so it created tremendous change in our perspective of how the Senate was going to act, at least based upon recent past. And it created a strong sense of wrong on the part of his supporters that the rules had changed And so the custom and the practice had not been adhered to. There was nothing unconstitutional about the change. It just was a change of expectations. And when there is a change of expectations along those lines, there's going to be some ruffled feathers. And there have been. And I think more ruffled feathers than one might have anticipated under the circumstances. The same thing is true on the other side of the political aisle with respect to President Obama's nomination of Merrick Garland as a judge. The Republicans took the position that no Obama appointee was going to be considered. Again, the Democrats argued that this was out of sync with the custom and practice, where this was not related to Judge Garland's qualifications. It wasn't even related to his ideology. It was related to which president should appoint when there's a split in power between one party, the Democrats who controlled the appointing process, President Obama, and another party led by Mitch McConnell, who were in control of the Senate and in control of their constitutional authority to advise and consent. And so there, the Democrats felt very aggrieved that the Republicans had changed the rules and that had not given a fair hearing or any hearing to Judge Garland. And it created a tremendous backlash, if you will, political backlash. I have to say that I was nominated to the number 3 position in the Office of Information and Regulatory Affairs in the Office of Management and Budget. We call it OIRA. And I wasn't given a hearing, so I can very much sympathize with Judge Garland, but I can also say that Judge Garland is not the first person who's been nominated to high office who was blocked from having a vote and was blocked for 6 months from even having a hearing. So I empathize and sympathize with him, but I have to tell him that he's not the first one to experience that. And with respect to Justice Barrett, Amy Coney Barrett, there was another question. Should she have been nominated by the winner of the presidency? In this case, it would have been Joe Biden, who looks like he'll be the next president, or should it be by the sitting president, President Trump? And again, the Democrats claimed that President Trump should have waited until the election. They claimed that that was the standard that was applied with respect to Judge Garland. The Republicans said, well, that kind of doesn't make the point. That was a case where the two parties were in control of different institutions that had constitutional obligations, and therefore waiting for an election was fair play. Democrats don't see it that way. They saw that the president should wait until the election, and that should be put to a vote of the people. So part of living in a constitutional democracy and custom and practice is figuring out how these norms operate. And every time there's a breach of norms, it pulls apart a little bit of the sinew of our system and creates political backlash and political problems. I'm not saying that there should always be deference. I think some things are worth fighting for, but in any war, even the winner loses, because there are always casualties, there's always harm in any battle, and something that I think our current president didn't quite figure out. Even if you win, you wind up losing if you fight too many battles and you take too many casualties. Okay, now the end result of this, and I want to give a few examples, and I'll get to the separation of powers. I want to make a few points here that people don't realize. First, on the selection of electors. Our election for president is handled by the Electoral College. Each state gets a certain number of electors, and the electors get to vote for the Electoral College. Our Electoral College vote will be, I think it's December 14 of this year, and the popular vote is really not determinative. We have 51 elections in 50 states plus the District of Columbia, and the way we've chosen to do that is through an election for electors. And the Supreme Court just this year ruled that the states can bind the elections, but only about half the states actually bind the electors. So we have what's called the problem of the faithless elector, so that an elector can choose for himself or herself whom to vote for. That rarely happens, but it's theoretically possible. Again, that's part of custom and practice. Electors are expected to follow the votes of the person to whom they're committed. This is more eye-opening, I think. There's nothing in the Constitution that mandates that we have an election for president. A lot of people don't even realize that. The choice of electors is up to the legislature in each state. Now, it turns out that the legislature in every state has chosen to allow the people to vote for the selection of electors, but there's nothing that mandates that. And in fact, during the 19th century, that was a pretty frequent occurrence. The legislatures chose the electors, and we didn't have a popular vote for the presidency. And there's nothing in the Constitution that requires that. The only thing by statute is that the Congress has chosen election day, this time November 3rd, as the date by which the states have chosen a path. So that if the states wanted to have changed the method of selecting the electors, they were entirely free to do that, but they probably had to do that before November the 3rd. Or the states, and this is what President Trump has been focusing on, if the election fails, then there's a statute that allows the legislature to step in and choose the electors. So President Trump has been trying to make the argument that the vote has failed, that there's been fraud, or there have been some kind of deficiencies in the election. He hasn't been able to make the case. But had he been able to make the case, then the issue would have gone to the legislatures in the states to determine who the electors would be. The last point along this line I want to mention is the seating of elections. Under the Constitution, each house, the House of Representatives and the Senate, gets to be the judge of the qualifications and of the election returns. So in these two House seats that are so close, 6 votes in New York, 12 in Iowa, this will go to the House for adjudication, for determination. The determination by the House is final. There is no judicial recourse. The Supreme Court, in a case from the 1970s called Roudebush against Hartke, has said that those decisions are to be determined by the House or the Senate. And so technically, people will recognize this, if one of the houses, the House or the Senate, decides that an election is spurious or wrong or inappropriate, as the claim is being made in Iowa, then the Senate or the House can choose not to seat a person on grounds that the election is not accurate or fulfilled. So technically, to pull the worst case scenario, if the Republicans now control the Senate 50 to 48, there's an election in Louisiana for these 2 open seats. If there's an election dispute in those states, the determiner will be the Senate, and the Senate will be controlled by the Republicans. And if you really believe that we don't have a culture of constitutionalism, then the Senate would be pressured to seat the Republicans and not the Democrats. I don't think that will happen, but there's nothing within our constitutional system that would preclude that from happening. There would be no recourse. The Roudebush case would say that the courts have no role in that regard. And so the Republicans could seat the Republican Senate candidates on grounds that there had been voter shenanigan or voter fraud or whatever. But again, I think that won't happen. I think that there will be the custom and practice to have an honest, open process where there will be a legitimate discussion of whether there has been fraud or not. So again, I think that's pretty eye-opening, that if you really wanted to play constitutional hardball, the Democrats who control the House could say, okay, the Republicans who are seeking these seats in the House, or in fact, all the new members of the House who are Republican, and they picked up about a dozen seats, they just wouldn't be seated. Nancy Pelosi and her colleagues would just say, you're a Republican, we're not going to seat you, and there wouldn't be recourse. The recourse would be, it would be all over the news, it would be all over the internet. There would be people even who would support Pelosi who would disagree with her position on that, just the way if the Democrats seated, if the Republicans seated the Republicans in the Senate and there wasn't a bona fide or legitimate process or claim, there are a lot of Republicans who would abandon the Republican leadership on this issue because of the culture of constitutionalism. Now let me turn quickly to the presidency. The presidency has tremendous authority. The president has authority and there are checks on authority. In the Korean War in the 50s, President Truman sought to seize the steel mills in the Youngstown steel case, and the Supreme Court said that he had acted outside of his authority. In order for the president to act, he needs to find a source of authority. It can be by statute, it can be by custom and practice if there's no statute, and it can be through inherent powers. The third category is very narrow, but it does exist. There are some things in which the Congress cannot check the president. So very recently in the Zivotofsky case, the Congress said that the capital of Israel is Jerusalem, but the administration, the Obama administration, the Bush administration, had not moved the capital of Israel to Jerusalem. And so Congress had said that a U.S. citizen who's born in Jerusalem can have his passport stamped born in Israel. The State Department refused to do that, said that's a contested issue. That's for negotiation between the parties, the Israelis and the Palestinians and others. And the State Department refused to abide by Congress's law. In the second Zivotofsky case, the Supreme Court said this is actually a power that the president has. The Congress cannot tell the president what to do. If the president does not want to recognize Jerusalem as the capital of Israel, then that's within the president's prerogative. Now in President Trump's time, he has recognized Jerusalem as the capital of Israel. And I just read recently that if you're born in Jerusalem as an American citizen, you can have your passport stamped that you were born in Israel. But that's a matter that the president can control. It's not something that Congress can control. That's a very narrow sliver, but that's out there. Most of the cases construe statutes. So when President Obama issued an executive order protecting these childhood arrivals, the so-called DACA personnel, that the question is whether he had authority under the statute or whether custom and practice gave him implicit authority to do that. And when the Trump administration tried to curtail him, the Trump administration was limited by the Supreme Court and said that they had not followed the proper procedures that are designed to constrain presidential power. So we see that constitutionally, the president can't seize the steel mills unless he has some authority to do that, or unless there's custom and practice that would authorize that, a gloss on the Constitution. And in the steel seizure case, the court said there was no explicit authority and there was insufficient custom and practice to justify that kind of activity. So that's the framework, the steel seizure framework that the court has used to adjudicate cases, including the Iranian assets case that I started out with. Okay, so how then has the power of the president been constrained? It's been constrained by putting procedures in place that limit the ability of these agencies to act. So the Administrative Procedures Act that was passed in the 1940s right after World War II puts a constraint upon the ability of these agencies to act. They have to explain what they're doing, give reasons for it, and they have to follow a law-like process. It's designed to take, as I often like to say, to take the politics out of politics. The president can often act because he thinks that's my policy, but under the Administrative Procedures Act, that's not enough. And I'll explain the case, the State Farm case. When President Reagan was elected in 1980, he ran on a platform of deregulation, and he tried to get rid of an airbag rule that had been put in place by the Carter administration. And the highway safety agency just pulled it out. So, President Reagan ran on this ground, deregulation, we're going to deregulate. We don't really have to give you that many reasons, saying that's the political process. We won, you lost. That's enough. Supreme Court struck that down. Said as long as this is being done through an agency process, there has to be reasons. Getting a political answer is not enough. It's not enough that President Reagan ran on this platform and he won. He has to give reasons, has to give an explanation. And part of the reason can be that we don't think on cost-benefit grounds that having an airbag rule is good. But guess what? The airbag rule has stood the test of time. But the Administrative Procedure Act puts constraints, puts limits on the ability of the president to act. And so here the pushback, the debate is between those who want to take the politics out of politics through something like a procedural constraint under the Administrative Procedures Act, and advocates of what's called the unitary executive principle that says basically you can't really take the politics out of politics because it eliminates accountability. It puts the power in the hands of unelected bureaucrats, and that ultimately what you really want is you want to have the president take accountability. And that's very much driven the Trump administration, where they believe that President Trump was elected and that he ran on a deregulation platform, and that he should have wide authority to deregulate and to embrace his policies as a matter of politics. And of course, President Biden will come back and say, well, you ran on one platform, I ran on a different platform, so I can undo your political determination. One of the advantages is if President Trump has opted through the Administrative Procedures Act to put various policies in place, like the airbag rule, then it will be much more difficult for President Biden to undo the policies that President Trump and his administration have put in place. And the DACA case is a good example where Trump tried to undo much of it. The Supreme Court said he didn't follow the procedures. You can do that, but you have to follow the procedures, give reasons and explanations, which the Trump administration didn't do. So that, I've gone over my time a little bit, but that I think is kind of where I'm going to stop and be open for questions and comments.
We deeply appreciate all of the knowledge that you have shared with us. And I find myself really kind of going, I didn't know that. I didn't know that. And so you have certainly increased our knowledge in this area and shown us that there's still a lot to learn about the Constitution that those of us, even in the League of Women Voters, don't know. So on that note, if you either want to type in questions, you're welcome to do that. Or if you are interested in just asking your questions, you may also do that. I'm going to go with what's been typed in first, though. And this is the first question. Can the president pardon himself in advance?
Oh my gosh. A listserv that I'm on among constitutional law professors has been dealing with this question. There's not, there's some source of authority that suggests he can't. There's nothing in the pardon power that limits his ability to do that. I'm skeptical that there are any limits. And I think that President-elect Biden has said that he's not going to go after the Trump administration. I don't think that certainly the Trump administration, for all the fights and battles it's engaged in, has never sought to go after Secretary Clinton or their predecessors. There's kind of been, again, custom and practice, an unwritten rule not to go after political adversaries. If I, out of abundance of caution, if I were advising President Trump, I would advise that it happened what happened during the Nixon time, to resign the day before and have President Pence, Vice President Pence become President Pence, do the pardon. That would end any question. Again, I believe in from a advice to client perspective and being conservative about that. But I think this is one of the things that common law professors like to argue about. I think it would be effective at the end of the day, even though there are serious arguments on the other side. As I said, I think if the president resigns, gives power for a day to President Pence, and then President Pence pardons the way President Ford pardoned President Nixon. I think there's no real serious doubt that'll happen. But you have to accept the pardon. And so President Trump would have to agree to accept the pardon, which would be some sign that the pardon is necessary.
Interesting perspective on that last sentence you offered us. Next question we've got here is regarding seating legislators. Does it mean any legislator or only ones that have a close race can have this happen? In other words, if Democrats win a Senate seat, could they refuse to seat McConnell?
I mean, if the Democrats,
if the Democrats are the majority party in the Senate,
yeah,
can they refuse to seat McConnell?
Yeah, it's a great question, and the Constitution says that each house shall be the judge of the election returns, so it doesn't have to be close. The Republicans can exercise that authority. It won't work for McConnell because of the timing. The January the 5th election will come, I believe, after the Senate is already in session and McConnell will have been seated. So it would have to be next time. And you can't, once a person is seated, there's a specific procedure for ousting a person, and you need a 2/3 vote to oust a person. Now, there's no criteria set in the Constitution for expelling a member. And so if the Democrats had 2/3 control, they could expel McConnell. They aren't going to have 2/3. I can't remember in my lifetime that either party has had 2/3. President Obama had 60 votes, but he would need 67. And I don't remember. It may be that President Johnson had close to that, but that's a huge margin in our political history. That's pretty rare. So yes, there's even a procedure for expelling someone, but you need 2/3 vote. Now, is there recourse to a court where there's been expulsion? There's no case that's decided that. I'm skeptical whether a court would hear that, but I think you would need 67 votes to do that, and I don't see that happening. Just the way you need 2/3 to convict for impeachment, and basically we had impeachment as a partisan matter. There was no Republicans who went along in the House. You only need a raw majority in the House. There's only one Republican senator that went along for conviction, far from having a 2/3 majority. There was not even a raw majority for impeachment. So, and that again, I didn't use that as an example, but no impeachment has gone forward without some element of bipartisanship. And I'm old enough to remember the Nixon impeachment, where there were significant numbers of Republicans who joined the Democrats. So that was a bipartisan effort. And Nixon resigned before he could be impeached, but he clearly was going to be impeached and probably, although you never know this, probably convicted as well. But certainly he would have been impeached, but it would have been on a bipartisan basis. This was not done with a single Republican vote. I think very unwise, and it pulls apart the sinews of our living together as a democracy.
Next question up. What are the possibilities that you see in a presidential popular vote compact altering the electoral college?
I'm sorry, say that again.
What are the possibilities that you see in a presidential popular vote compact altering the electoral college?
Oh my God, this is another issue that is Governor Conlaw listserv. Just so people know, there is a proposed compact floating around that says that the state will give its electoral votes to the candidate who wins the popular vote nationally. Again, we don't have a clear answer to this. I have actually done work on the compact clause, and I think that a rule like this would probably have to be under the compact clause approved by the by the Congress. Our work concluded that the president doesn't have veto power over congressional consent, but that's a highly disputed issue. But I think it would have to get approval by the Congress. This compact is not going to have its approval. There's also a question as to whether the Constitution says each state shall determine its electors. And one school of thought is, well, the legislature can determine that it's going to choose its electors by deferring to the popular vote in other states. And so that's a legitimate position. The other side of that, very strongly argued that I've seen, is that when the legislature is given this authority, it cannot delegate that authority. It can delegate it to a popular vote within the state, but it can't delegate its authority to voters outside the state. The system has to be state by state. That's the structure of our Constitution. I don't think that's going to happen as a practical matter, but I think it would be hotly contested and hotly disputed, and there are reasonable arguments on both sides of that. I come down personally on the side that it would require congressional approval under the Compact Clause, and I am more persuaded by the arguments that I've seen online that say that the process can't be delegated outside of the state. It can be delegated to the voters within the state, but our system of elections is a state-by-state system of elections, and we would undo the electoral college concept. You know, when people talk about the popular vote, I have to laugh. You know, I used to play tennis, and in tennis, you win by how many sets you win. If you have a 5-set match, you win 3 sets, that's it. You can't go back and say, well, I won my sets 2 sets to love, and therefore I have 12 games in the basket, and I lost the other sets on a tiebreaker 7-6. And therefore we should go back and count who won more games. That's not the system. The system is who wins more sets, and who wins more games is not the system. The same as when you play match play in golf. To use, again, I'm sorry if it's a sports metaphor. I've been counseling sports metaphors, but they're very apropos here. You do match play as opposed to medal play. In medal play, you add up all the strokes. In match play, you do it by hole. Which hole have you won? It's like the electoral college system. And I think we have a system that is essentially match play. You do it state by state, and you have an electoral college. Now, each state has the authority, and we have 2 states that give some votes to winners of the district. So Maine has 2 districts, and you get a certain amount of votes for winning the state, and then each district winner gets some votes. The same is true in Nebraska. So if you're worried about the winner-take-all system, that could be done. In fact, it would advantage, a tremendous advantage to the Republicans in California, because California is a winner-take-all proposition, and California gets 55 electoral votes, and it's pretty much uncontested. I think 70% of the vote went to Vice President Biden. They get 55% of the votes, but at the state level, that means 30% of the votes for electoral college would go to Republicans, which would be 15 or so votes that the Republicans don't have. The same is true for the Democrats in Texas, because that they get a proportionate share. But that has not been done, to my knowledge, ever. I don't want to say ever, because I haven't done the history, but certainly in the last post-Civil War period, that has not been done. There's never been a proportional representation, but that could happen within our constitutional system without an amendment. A state could choose to allocate its electoral college electors by the proportional winner of the statewide vote, or by a congressional district.
Next question. Boy, these questions just keep on popping up for you, Jim. I think you've got a lot of us thinking. Why can a POTUS remove the U.S. from negotiated agreements like the Paris Accord and the Iran nuclear deal? It seems as if that should take congressional approval.
Yeah. Well, again, this is a great issue. Most of those agreements, like the Paris Accord, was never ratified. It's not a treaty. In order to be a treaty, it has to be ratified by the Senate. The Paris Accord is a non-agreement. It's an agreement to agree. There's no there. And so that's a pretty easy one. And it has a procedure for opting out. The harder one is on something like recognition of mainland China. We had a treaty with Taiwan, and President Carter opted out and gave recognition to mainland China. But at the time, he made the argument that that's an authority that exists within the president. So historically, the president can enter into an agreement, and if it's a treaty, the president needs 2/3 approval by the Senate. The House has no role in approving a treaty. But the understanding usually is that the president is in control of foreign policy, and if the president wants to out the country from a treaty, that's within the president's foreign policy authority. Just as the president can fire someone, he has to get confirmation, but unless that person, like a Supreme Court justice or any federal judge, is protected by the Constitution. But if the president wants to fire someone, there's a Supreme Court case says that he doesn't have to go back and get congressional approval. Congress has to ratify the appointment, but the president has authority to terminate that person in office. It's the same idea with these agreements.
Wow.
And it's a closer call with treaties, but even in the context of a treaty, I think it's pretty well accepted that the president can undo a treaty without having to get Senate approval.
Okay, going in a little bit different direction here, but still looking at the president and the Constitution. How can the census be challenged when the Constitution clearly says all persons must be counted?
Yeah, that case was just argued before the Supreme Court this week. The president wants to exclude, I think the language in the Constitution is whole persons. It's one of our embarrassing parts of our history is that in the Constitution, we all learned in civics that there was the 3/5 compromise, that slaves were counted as 3/5 for purposes of apportionment and for taxation. And so whole persons has a meaning, and the argument is that whole persons means citizens, that a whole person is a person who's subject to the authority of the United States and has full authority, and that the interpretation is one that is open to interpretation by the executive branch. Whether the president can do this is an interesting question. On reapportionment, one person, one vote, there is a case, the Evanwall case from 2 years ago, where the question was whether states could only count citizens. The Supreme Court backed off from that and said, no, states are free to count everyone within their border, even non-citizens. But they left it open that the states could choose to count citizens if they wished. How that would be defined was to be left up to the state. So I haven't seen the briefs in this case, but that's how, if I were representing the government, if I were the Solicitor General in the state, that in the federal government, that's where I would go, is that the definition of persons is open to interpretation, especially in the context when we had the 3/5 compromise. Some persons were not persons, that whole persons mean citizens, and that the purpose for determining who is here for purposes of apportionment, for purpose of distributing federal largesse, for example, that this is a matter up to the executive branch to interpret. I'm not sure the president's going to win that case. I think that issue is up for interpretation, and he may very well lose. But that's the argument, is that persons does not necessarily mean non-citizens who may not be subject fully to the jurisdiction. So everyone seems to concede that if you are a non-citizen and you're here in the U.S. to come to Vanderbilt for a one semester visitor or something of that type, you don't have to be counted. Or if you're a tourist, you don't have to be counted. You're a person, you're in the United States, but you don't have to be counted. So the question is, do you have to be counted if you're not a full-blown citizen of the, can you be treated like a tourist, or can you be treated like a temporary resident? That's the answer.
Okay, well, our time is just about up. I'm going to toss this back to Marion because I don't know if she's got some other things that she's wanting to cover before we bring the meeting to an end. But let me end our section, Jim, by just saying how very much I appreciate your being with us and sharing your immense knowledge about constitutional policies, constitutional law, and how all this impacts on all of us right this minute. And I think it's been brought to the forefront more than any time that I can remember since our present president has been in office.
And yes, I want to add my thanks to Carol. We really appreciate your historical as well as current views on the Constitution and the powers of the presidency. I wish you were around more often so we could ask you every question as they raise them, as they come up in the media. But anyway, thank you very much. And thank all of you who took time to come. Wish you happy holidays. This is going to be a different one for all of us, but we will get through it because we are strong. We are invincible. We are women and men. Take care.
Thank you.
Bye-bye.
Thank you.
I know.
Awesome.